Welcome to episode 34 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name's Bailey, and I'll be reading the Supreme Court's opinion in Zorn versus Linton. The case was decided March 23rd, 2026. And there is no syllabus for this case, so we'll move right on to the opinion, which is written per curiam. On the governor's inauguration day in Vermont, protesters staged a sit-in at the state capitol. When the capitol closed for the day, police officers told them that they would be arrested for trespassing. They refused to leave. As officers removed the protesters one by one, Sergeant Jacob Zorn asked Sheila Linton to stand up and warned her that he would eventually have to use force to remove her. She refused to stand. Zorn took Linton's arm, put it behind her back, placed pressure on her wrist, and lifted her to her feet. Linton sued Zorn for using excessive force, claiming that the arrest left her with arm injuries and psychological disorders. The Second Circuit held that Zorn was not entitled to qualified immunity. We reverse. Part 1. On January 8, 2015, Vermont hosted the inauguration for Governor Peter Shumlin in the Capitol. Footnote 1. Because this case comes here on Zorn's motion for summary judgment, we view the facts in the light most favorable to the non-moving party, Linton. Carrying on. About 200 protesters attended, and some of them staged a sit-in to demand universal health care. Sheila Linton joined them. She planned to refuse to leave and anticipated being forcibly removed. That's the point of the sit-in part of the protest, she later explained. When the Capitol closed to the public for the night, 29 protesters remained in the legislative chamber, sitting on the floor with their arms linked. At that point, police officers explained that they would arrest the protesters for trespass if they did not leave. The officers dealt with them one at a time. Some stood up and were escorted out of the chamber without force, but others refused to stand and had to be lifted to their feet or dragged out. After removing more than a dozen protesters, the officers turned to Linton. Sergeant Jacob Zorn crouched down to speak with her, but she remained seated with her arms interlocked with those of her fellow protesters. As Linton passively resisted, Zorn unlinked her arm from another protester's, put it behind her back in a rear wrist lock, and twisted her arm. Footnote 2. A rear wrist lock is a technique that officers use to gain control over a resistant person by gripping his wrist, placing it behind his back, and bending it backward. Carrying on. Linton exclaimed, "Ow, ow, ow," while Zorn repeatedly implored her to please stand up. After Linton responded, "I will not stand up," Zorn told her that he would ask one more time and then would use more pain compliance. Linton refused, so Zorn placed pressure on her wrist and lifted her up by her underarm. Linton yelled as she stood up. Once on her feet, Linton continued to jerk her arms and fell back to the floor. Zorn asked her to stand up again, and when she did not, 3 officers picked her up by her arms and legs and carried her outside. Linton alleged resulting physical and psychological injuries, including post-traumatic stress disorder. Linton sued Zorn under Revised Statute Section 1979, 42 U.S.C. Section 1983, claiming that Zorn violated her Fourth Amendment right against excessive use of force. The district court granted summary judgment for Zorn after concluding that he was entitled to qualified immunity. The district court reasoned that it was not clearly established at the time of the encounter that in these circumstances, lifting Linton while putting pressure on her wrist violated the Fourth Amendment. The Second Circuit reversed. It held that its decision in Amnesty America v. West Hartford clearly established that the gratuitous use of a rear wrist lock on a protester passively resisting arrest constitutes excessive force. It remanded for a jury trial against Zorn. Judge Cabranes dissented. "The case before us is not an exceptional case," Judge Cabranes reasoned, "but a routine arrest and removal." Part 2. Government officials enjoy qualified immunity from suit under Section 1983 unless their conduct violates clearly established law. A right is clearly established when it is sufficiently clear that every reasonable official would have understood that what he is doing violates that right. A right is not clearly established if existing precedent does not place the constitutional question beyond debate. To find that a right is clearly established, courts generally need to identify a case where an officer acting under similar circumstances was held to have violated the Constitution. The relevant precedent must define the right with a high degree of specificity so that every reasonable official would interpret it to establish the particular rule the plaintiff seeks to apply. Principles stated generally, such as that an officer may not use unreasonable and excessive force, do not suffice. In short, officers receive qualified immunity unless they could have read the relevant precedent beforehand and known that it proscribed their specific conduct. The Second Circuit contravened these principles. Amnesty America did not clearly establish that Zorn's specific conduct violated the Fourth Amendment. Footnote 3. We assume without deciding that controlling circuit precedent can clearly establish law for qualified immunity purposes. Carrying on. Whether any particular use of force violates the Fourth Amendment depends on the facts and circumstances of each particular case, including whether the officer gave warnings before using force. In Amnesty America, the court considered a wide range of allegations of excessive force. The officers rammed a protester's head into a wall, dragged another protester across the ground, and used rear wrist locks on 2 more protesters to lift them up before throwing one of them to the ground. Nothing indicated that the officers gave the protesters any warning that they would use such force. Amnesty America did not hold that any of those actions violated the Fourth Amendment, let alone all of them. Instead, it remanded for a jury trial because, while a reasonable jury could find that the officers gratuitously inflicted pain, it was also entirely possible that a reasonable jury would find that the police officer's use of force was objectively reasonable given the circumstances. Relevant here, Amnesty America even relied on a decision approving the practice of warning protesters and then using wrist locks to move them. Reasonable officials would not interpret Amnesty America to establish that using a routine wrist lock to move a resistant protester after warning her without more violates the Constitution. Zorn repeatedly warned Linton that he would have to use more force if she did not stand up, and when she did not do so, he used a wrist lock to bring Linton to her feet. Amnesty America never held that such conduct alone violated the Fourth Amendment. If anything, it implied the opposite. And its statement that officers who had engaged in a wide range of aggressive conduct may have used excessive force did not put Zorn on notice that his specific conduct was unlawful. The Second Circuit concluded otherwise by reading Amnesty America to establish the general principle that the gratuitous use of pain compliance techniques, such as a rear wrist lock, on a protester who is passively resisting arrest constitutes excessive force. But that principle, even assuming Amnesty America established it, lacks the high degree of specificity needed to make it clear to officers which actions violate the law. It does not obviously resolve whether using a rear wrist lock to move a non-compliant protester after repeated warnings violates the Fourth Amendment, as it fails to specify which circumstances make the use of force gratuitous. Because the Second Circuit failed to identify a case where an officer taking similar actions in similar circumstances was held to have violated the Constitution, Zorn was entitled to qualified immunity. We grant his petition for writ of certiorari and reverse the judgment of the Second Circuit. It is so ordered. Justice Sotomayor, with whom Justice Kagan and Justice Jackson join, dissenting. Sergeant Jacob Zorn used a pain compliance technique called a rear wrist lock on Sheila Linton, a nonviolent protester who was peacefully demonstrating at a sit-in in the Vermont Capitol. The Second Circuit held that Zorn was not entitled to qualified immunity on Linton's Fourth Amendment excessive force claim, at least at the summary judgment stage, because prior circuit precedent had clearly established that using a rear wrist lock against a nonviolent protester would violate the protester's constitutional rights. That decision was not erroneous and certainly not so clearly erroneous as to warrant the extraordinary remedy of a summary reversal. I respectfully dissent. Part 1. Given that this case is at the summary judgment stage, the court must view the evidence in the light most favorable to Linton, the non-movement, with respect to the central facts of the case. Before Sergeant Zorn's interaction with Linton, officers had arrested 15 or 16 demonstrators. The officers tapped some of the demonstrators' shoulders or spoke briefly with them before the officers placed them under arrest. Some of the arrestees voluntarily stood up after officers approached them, while the officers lifted the demonstrators who did not stand up voluntarily and escorted, dragged, or carried them out of the chamber. Consistent with the concept of a nonviolent sit-in protest, none of the demonstrators attacked the officers or used any form of violence. One officer, Trooper Richardson, described the level of safety threat in the environment as very low. When Zorn and Richardson first approached Linton, they did not issue any clear request or command, and the video evidence appears to indicate that one of them said only, "Ma'am." About 5 seconds later, Zorn and Richardson unlinked Linton's arms from the other demonstrator's arms. Without any warning, indeed without saying another word to Linton, Zorn placed Linton's left arm into a rear wrist lock by twisting her arm and shoulder, snapping her wrist and forcing it down to the rear. Linton immediately exclaimed, "Ow, ow, ow." Only then did Zorn instruct Linton to please stand up. Linton did not stand up, at which point Zorn further twisted Linton's arm. Linton's face contorted in pain as she stated, "My arm," or "Don't twist my arm." Zorn asked Linton to stand up several more times. Linton refused and replied, "You're hurting me." Zorn then warned Linton, "I'm going to ask you one more time, and then I will use more pain compliance." Linton repeated that Zorn was hurting her and did not move to stand up. Zorn then applied pressure to Linton's wrist and lifted her upward, causing Linton to contort her face in pain and scream very loudly. Zorn whispered to her that she should have called her legislator. After being hauled to her feet, Linton collapsed back onto the floor due to pain and feeling weak. Zorn, Richardson, and a third officer lifted her by her arms and legs and carried her out of the house chamber without further use of a rear wrist lock or any other pain compliance technique. As a result of this event, Linton suffered permanent damage to her left wrist and shoulder and has been diagnosed with post-traumatic stress disorder, depression, and anxiety. Part 2. Officers are not entitled to qualified immunity if 1. They violated a federal statutory or constitutional right, and 2. The unlawfulness of their conduct was clearly established at the time. The Second Circuit correctly held that summary judgment must be denied because a jury could find that Zorn violated Linton's clearly established Fourth Amendment rights. Section A. Starting with the first prong of the qualified immunity analysis, Linton contends that Zorn violated her Fourth Amendment rights by using excessive force during her arrest. Determining whether a given use of force is excessive requires a careful balancing of the nature and quality of the intrusion on the individual's Fourth Amendment interests against the countervailing governmental interests at stake. The inquiry depends on the totality of the circumstances, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, whether she is actively resisting arrest or attempting to evade arrest by flight, the relationship between the need for the use of force and the amount of force used, and the extent of her injury. Here, the Second Circuit rightly concluded that a reasonable jury could find that Zorn's use of force was excessive in violation of the Fourth Amendment. First, the crime of trespass for which Linton was arrested is not particularly severe. Second, it is undisputed that the threat to safety posed by Linton was relatively low. Trooper Richardson described the level of safety risk as very low. The protesters also passed through security and therefore must have been considered to be unarmed, did not significantly outnumber police, and were not accused of being volatile or violent. Third, it is also undisputed that Linton suffered permanent loss of motion in her left wrist and shoulder as a result of the incident. Fourth, there is a material dispute of fact as to whether Linton was actively resisting arrest, and a jury reasonably could conclude that Linton was only passively resisting and that her failure to comply was because she was in too much pain to do so. Finally, a jury also reasonably could conclude that the use of pain compliance was not reasonably related to any need to use force. The officers purportedly did not use pain compliance techniques in the arrests of fellow protesters, and Linton contends that the Vermont State Police use of force policy does not suggest using pain compliance techniques in response to passive resistance. Further, Zorn's own expert stated that the general police practice in response to passive resistance is low-level physical contact with little or no pain. Taken together, a jury could reasonably conclude that Zorn used excessive force in violation of Linton's Fourth Amendment rights. Section B. The second prong of the qualified immunity analysis asks whether the unlawfulness of the official's conduct was clearly established at the time, which requires assessing whether the contours of the right are sufficiently clear that a reasonable official would understand that what he is doing violates that right. Earlier cases involving fundamentally similar facts can provide especially strong support for a conclusion that the law is clearly established, but there need not be a case directly on point. In addition to the long-established principle that officers may use only the amount of force that is necessary in a particular situation, the Second Circuit's prior case, Amnesty America v. West Hartford, clearly established that the gratuitous use of pain compliance techniques, such as a rear wrist lock, on a protester who is passively resisting arrest constitutes excessive force. In that case, officers used multiple forms of force to arrest anti-abortion protesters who had chained themselves together in front of a women's center. The plaintiffs alleged that the officers had used excessive force to remove them, including by using a rear wrist lock and other pain compliance techniques. Two plaintiffs in that case were treated much like Linton was. Officers lifted and pulled them off the floor by pressing their wrists back against their forearms in a way that caused lasting damage. The circuit then held that under past cases, allegations involving comparable amounts of force used during the arrest of a nonviolent suspect are sufficient to allow a reasonable fact finder to conclude that the force used was excessive. Amnesty America's specific discussion of rear wrist locks thus clearly established that using a rear wrist lock against a nonviolent, passively resisting protester could constitute excessive force. It therefore put Zorn on notice to a high degree of specificity that using the same technique against a passively resisting protester like Linton would expose him to liability for violating Linton's Fourth Amendment rights. Section C. The court's attempts to distinguish Amnesty America are mistaken. It first claims that Amnesty America differs from this case because the officers there did not give any warning to the protesters while Zorn repeatedly warned Linton here. That distinction misrepresents both cases. Amnesty America, in fact, did involve warnings. It observed that the police purportedly employed the pain compliance techniques only after they were unsuccessful in verbally convincing protesters to move. By comparison, in this case, construing the evidence in favor of Linton as is required, Zorn did not issue any clear request or command before applying a rear wrist lock and began asking her to stand only after he had initiated the wrist lock. Amnesty America thus involved an officer acting under similar circumstances and put Zorn on notice that his actions would violate established law. It is true that, after initiating the wrist lock, Zorn warned Linton that he would use more pain compliance if she did not stand up, whereas the Amnesty America opinion does not specify whether similar warnings were given after the initiation of the wrist locks. If that is the difference on which the majority relies, the majority is essentially requiring Linton to find a factually identical case, a requirement that this court has repeatedly rejected. The majority also suggests that Amnesty America considered a wide range of conduct, implying that it did not specifically address rear wrist locks like the one at issue here. That, too, is inconsistent with the actual opinion, which recognized that each plaintiff had standing to assert only those constitutional deprivations that they themselves were alleged to have suffered, and specifically identified the use of a rear wrist lock against some passively resisting protesters as sufficient to allow a reasonable fact finder to conclude that the force used was excessive. The court next reasons that Amnesty America did not clearly establish any law because it stated that while a reasonable jury could find that the officers used excessive force, it was also entirely possible that a reasonable jury would find that the police officers' use of force was objectively reasonable given the circumstances and the plaintiff's resistance techniques. These statements in Amnesty America, however, reflect that the Second Circuit was reviewing a district court's grant of summary judgment in favor of the defendants where there was factual uncertainty. In reversing the grant of summary judgment, the Second Circuit held that if the plaintiff's allegations were true, they would be sufficient to allow a reasonable fact finder to conclude that the force used was excessive, but it found that there were material disputes on issues of fact that could not be resolved at summary judgment. Thus, when Amnesty America stated that a reasonable jury could rule for the officers, it was merely acknowledging the reality that the jury might well resolve those material factual disputes in favor of the defendants and find that the officers' use of force under the circumstances that truly occurred was not excessive. That possibility, however, does not change the fact that the Second Circuit held the use of a wrist lock could be excessive if events had transpired the way plaintiffs alleged they had in that case. Indeed, the Second Circuit has long held that a vacatur of a grant of summary judgment and a remand in light of the existence of genuine issues of material fact may clearly establish a constitutional violation, and the dissent below agreed. At bottom, the majority's analysis rests on the assumption that the law can be clearly established only by factually identical cases directly on point, despite the court's rejection of such a standard. Instead, it is enough that governing law places the constitutionality of the officer's conduct beyond debate. Here, taking the facts in the light most favorable to Linton, it is beyond debate that Zorn's use of pain compliance against the passively resisting Linton was excessive. Accordingly, Zorn was not entitled to summary judgment based on qualified immunity. For the foregoing reasons, the Second Circuit did not err in holding that Zorn is not entitled to qualified immunity at this stage. At the very least, the decision below was not so wrong as to warrant the extraordinary remedy of a summary reversal. Relying on disputed facts, the court today simply disagrees with how the Second Circuit applied a correctly stated legal standard, the requirement that law be established to a high degree of specificity in the qualified immunity analysis, to this particular set of facts. That is a routine and nowhere near extraordinary dispute that did not require the court's intervention. In the past, I have noted the troubling asymmetry in this court's unflinching willingness to summarily reverse courts for wrongly denying officers the protection of qualified immunity, but rarely intervening where courts wrongly afford officers the benefit of qualified immunity. This case unfortunately represents a resurgence and perpetuation of this one-sided approach to qualified immunity that transforms the doctrine into an absolute shield for law enforcement officers, gutting the deterrent effect of the Fourth Amendment. The majority today gives officers license to inflict gratuitous pain on a nonviolent protester even where there is no threat to officer safety or any other reason to do so. That is plainly inconsistent with the Fourth Amendment's fundamental guarantee that officers may only use the amount of force that is necessary under the circumstances. Therefore, I respectfully dissent. And that does it for the opinions in this case. I guess first I'll kind of speak to the legal merits. Yeah, I'm not really sure if the court got it right here because it kind of depends entirely on how you read the Second Circuit's Amnesty America precedent, and I haven't read it. Frankly, I don't plan to read it. Yeah, I think the fact that you've got 6 justices on one side, 3 justices on the other, both reading this precedent completely differently, it's really hard to imagine how an officer, average police officer, could have read that precedent and come away with the, clear conclusion this conduct is unconstitutional. So at least as the standard for qualified immunity stands, that the officer's conduct has to violate clearly established law, meaning, clearly established meaning that the officer could have read the existing law on the issue and come away with the understanding that the constitutionality of his conduct was beyond debate. I lean in the direction that the court got it right. Because again, it's apparently unclear to the Supreme Court of the United States, at least on the whole. And much of the dissent seems to be almost criticizing that standard and qualified immunity itself more than criticizing the court's application of it. I mean, it's certainly phrased as criticizing the court's application of it, but it almost feels more like a criticism of the standard itself, like, oh, it presents basically a shield to law enforcement officers engaging in unconstitutional conduct. It effectively requires identical circumstances and identical case on point in order to quote unquote clearly establish this specific conduct as unconstitutional. And these are all criticisms you will hear of qualified immunity and the standard for granting qualified immunity itself, not usually specific applications of it. Because, frankly, qualified immunity and the standard for granting it kind of do those things. They kind of do present almost complete shields to officers engaging in unconstitutional conduct and almost do require literally identical circumstances before the courts will be willing to deny qualified immunity because, the standard is clearly established law, and one of the most obvious indicators that the law is clearly established is that you've got a case on point, you've got precedent on point, and there's a seemingly infinite number of ways to distinguish any individual case from any other, and judges wanting to grant qualified immunity will find them. And I guess this kind of gets into, away from the legal merits and into what I think about qualified immunity and the standard for granting qualified immunity. And yeah, I don't like qualified immunity at all, and I definitely don't like the standard for granting it. On qualified immunity itself, at least as far as I'm aware, it's this purely judge-made doctrine. It doesn't come anywhere from the Constitution. It doesn't come anywhere from the laws of the United States. It's at most thinly grounded in, sort of background, like long-standing background doctrines like sovereign immunity and stuff. And then when it comes to the Section 1983 context specifically, at least as I understand it, the sort of basis for applying qualified immunity to the Section 1983 context is, the court has said if Congress is establishing a cause of action against government officials acting in their official capacity, then we're going to presume that cause of action does not abrogate qualified immunity, this sort of like background doctrine, this background immunity that predates the statute establishing this cause of action, unless Congress says so, unless they say clearly we're abrogating qualified immunity, right? Or there's some other textual, clear textual indication that Congress intends to abrogate qualified immunity. And I mean, for one, that also is this like just purely judge-made sort of rule. And for two, there's kind of a complicated history of Section 1983 specifically, where the original version of Section 1983, as originally ratified, did explicitly abrogate qualified immunity and any other immunity that would have sort of gotten in the way of this cause of action that it was establishing. And then apparently that clause abrogating qualified immunity was, for some reason, dropped when Section 1983 was brought into what is today the United States Code, because previously statutes were just kind of listed uh, in chronological order that they were adopted, which made things really difficult to determine, okay, what is the current state of the law? Because you had, laws not grouped together in any coherent sense. It was just chronological order of ratification. And so when these laws were taken and organized into what is today the United States Code, they were just supposed to be just that, taken and organized, not modified, not amended. The state of the law was not supposed to change. But for some reason, that substantive legal provision of, that substantive provision of Section 1983, abrogating all of those immunities, got dropped. And so there's this complicated history of like, well, it seems like the ratifying Congress did intend Section 1983 to abrogate qualified immunity. And, yes, it was re-ratified uh, without that provision. But given the history, it's, really, it's really strange to say, oh, well, that was intentional. That change in the state of the law was intentional. But anyway, all of that to say, I don't like qualified immunity. I especially don't like qualified immunity as applied to the Section 1983 context, just on the legal merits of the thing, I don't like it practically either, because it does shield law enforcement officers from consequences of unconstitutional, unlawful actions. And then the standard for granting qualified immunity is just so favorable to government agents. It has to be clearly established law. And yeah, I mean, I've sort of addressed this already. There's any number of ways to, distinguish something, some case, something which might clearly establish the unconstitutionality of some specific actions from the actual actions that occurred. And the courts can say all they want, oh, we're not demanding identical circumstances, but in all practical reality, they kind of do. Yeah, and then there's all sorts of other issues like that denials of qualified immunity are immediately appealable. And I believe that has to do with something that was discussed in a recent episode, the collateral order doctrine, where there's certain judgments that, while they don't end the case, and so normally wouldn't be appealable, are nonetheless appealable, like the denials of certain immunities. Yeah, and as I understand it, qualified immunity is one of those. So, judge denies qualified immunity, and then despite the fact that the litigation is still ongoing, the officer, the official, can immediately appeal that denial of qualified immunity, and then everything just gets hung up in the courts while the litigation over whether the officer should get qualified immunity is ongoing. And I mean, you see that in this case where the conduct at issue here is from 2015. I'm, for reference, recording this in 2026. It was 11 years ago. And this is just at the summary judgment stage. This is like at the very start of the case, and just now, finally, you've got the Supreme Court finally deciding this issue, and granting qualified immunity. And then if the Supreme Court hadn't granted qualified immunity, right, this would go back down for the actual litigation through the case. And, who knows how much longer that would take, and if it would, if this would get hung up in future steps on qualified immunity issues again. I don't know. I'm not super familiar with the procedures. As I've said before, not a legal expert. But all of that to say, this qualified immunity and immediate appealability of denials of qualified immunity just hang things up and slow things down in the courts. And remember, you're talking about suits seeking redress under Section 1983, often for deprivations, alleged deprivations of constitutional rights. I mean, it covers statutory rights as well, but, these are Section 1983 suits are often the product of constitutional deprivations, as here, alleged constitutional deprivations, as here, Fourth Amendment rights. Now that said, reading through the background of the case, I'm kind of, I kind of found myself like cringing at the allegations, the factual allegations, and it doesn't strike me as a particularly meritorious case, but I I don't know, maybe it is, and maybe I'm just biased or whatever, but it's like, "Oh, I suffer PTSD because an officer pulled me out of a legislative chamber that I knew I was trespassing in, and that I knew I was going to be pulled out of forcibly by the police." Like, okay, and after you saw 15 or 16 of your fellow protesters be forcibly removed, it's like, "Okay, really?" But, whatever. It's very far besides the point. I've been rambling very far beside the point for a minute now. So, anyway, with all of that said, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you would like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members get access to bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode, where we'll continue on through the Supreme Court's 2025 term. Until then.